An ounce of mediation is worth a pound of arbitration and a ton of litigation. A very good evening to you, ladies and gentlemen. Law Essentials welcomes you to the sixth episode of the Lawyers as Peacemakers monthly series. Our topic for discussion today is mediation. We have with us Professor Carolyn Gas, Ms. Nithya Bansal, and Ms. Meena. Professor Carolyn is the co-director of the Center on Dispute Resolution of Quinnipiac University Law School. Ms. Nithya Bansal is an advocate who, after feeling dissatisfied with litigation as a means of dispute resolution, switched to family and communication mediations in 2015. Other than that, she trains in conflict resolution and mediation. She recently completed her MA in Peace Studies in Costa Rica. We also have with us Ms. Meena, who is the founder of OutOfCourt.in. She resolves family, civil, and commercial disputes through the process of mediation. She conducts several training sessions in mediation. She organized the first ever Young Mediators Training Program in India for students from 9th standard to 11th standard, which was conducted in 2017. It's a pleasure having you all with us today. Thank you so much for joining in. I would like to ask Carolyn to start off.
Welcome, everybody. It's a real honor to be here, and thank you to Professor Kim Wright for inviting me. Yes, indeed, I am at Quinnipiac University School of Law, which happens to be in Connecticut, right outside of New Haven. My law school is actually the leading law school in our state in dispute resolution, and if you know anything about Yale, you know that's saying quite a bit. In fact, Yale and Quinnipiac cooperate together to host a speaker series for both practitioners and students. So we work closely with our colleagues, but we are the #1 ADR school in our state, and frankly, we are the 18th ranked law school in the whole US in dispute resolution. So I'm very proud of what we've built over the last 20 years. I'll say a little bit about what we do at Quinnipiac, not because I'm trying to do a commercial for Quinnipiac, but I think what we're doing at Quinnipiac just actually is an example of where we are in the mediation field in the whole US. We are on the leading edge. We are a groundbreaker along with, we're not alone in that, but I think it will also help you to see the future of where dispute resolution is going, and particularly mediation. So I'm not actually sure. I'm very interested to hear from my colleagues to learn more about what's happening where you all are. But I would say a couple things about mediation in the US. It actually started with non-lawyers. It did not start in the legal profession where we are. And it started in communities, in what we call grassroots, growing up of how to resolve disputes without having to go to lawyers and courts. And it started sort of in family law. And we're talking 30, 40, 50 years ago and earlier, but it was really starting to take root 40 or 50 years ago. In addition to the community centers, which were really about gathering people together and developing mediation theory and learning how to resolve problems. This came at a time when negotiation theory was evolving into what we would call interest-based or problem solving, or some people called it principled negotiation. So it was really coming from a few different directions and vectors to really help people stop the very adversarial approach to problem solving, which, you know, in the olden days was duels and shooting and beating each other up. Certainly litigation was a positive step from that. But litigation was costly, time-consuming, and not very satisfying, especially when there was a relationship. So neighborhood mediation is where it started, and it quickly jumped to family law. So I think, Meena, you would agree with me that family law was one of the first places in the courts where it really took hold, and that is one of my specialties. But again, wherever relationships matter, you're going to find people really searching for a better way to solve their problems, reach agreements. And so it's not surprising at all that people who do business deals have long been doing negotiation in a more collaborative, cooperative way. They don't always need to use mediation, but when they do, because they're trying to make a deal to work together, right? And I think what happens in litigation, and certainly we've been exploring this at Quinnipiac, both in theory and practice, what happens is that when people are in conflict, they don't think about what the impact is on their relationship. They're worried about what happened to get us upset with each other. And so litigation seemed a natural place to go for so long. But when relationships matter, and what that means is whether it's past relationship or more importantly, what do you want your relationship to be in the future? Then you find people searching for a better way. And you may already know all this, and I apologize if you do, but I'm saying this is what we were thinking in the US as well. So family law, neighborhood disputes, and business deals, of course. It still has not necessarily spread to all the places where it should. So I am involved in the following ways. We have a very strong coursework at our law school, and you can even get a concentration or a specialty or a major or a certificate, whatever you'd like to think of it as, in law school in dispute resolution. Not at every law school, only maybe 20 or 30 of us, but my law school, yes. And that requires coursework in negotiation, mediation, arbitration, and litigation too. We want you to know what that is, but much deeper work in negotiation and mediation. So that's one way. We have clinics, and I'll explain those a little bit. And this is really, again, an example of what's going on in the US in law school. Because although I told you that it kind of started not with lawyers, it immediately jumped to law schools and lawyers getting involved in mediation as more and more areas of law said there's got to be a better way. Now, sometimes it was courts, sometimes it was community mediators and private mediators, but it was definitely really lawyers began to get involved in mediation. And there was a danger for a while, and it still exists, that lawyers changed mediation instead of mediation changing lawyers. So my law school is devoted to mediation changing how we train lawyers so that they do not go out there and frankly ruin mediation by making it very adversarial, evaluative, meaning here's what would happen in court, so here's what you should do. The idea in mediation, as my guess is you already know, is to find solutions that are more creative and more satisfying that a court would do, and to empower the people with the dispute or who want to make the future deal to do it in a way that is more sort of win-win and not win-lose. So if lawyers just come in and do what they do in the courtroom and do that in the mediation room, they ruin that potential. And they're fighting with each other on behalf of their clients where there's not even a judge to make a decision. So it's a complete waste of time. So that is why we and other law schools are so intent on bringing mediation to the law, offering it as another way to resolve problems, and helping to teach lawyers to be different in the way in which they solve problems. So, as I said, we have courses, and we have clinics, and we have student teams. We actually, it may sound silly, but we actually go out and compete in non-competitive skills. And in a way, people think that undermines it. But in reality, when when students go and negotiate in a negotiation competition or in a mediation competition, really they're not trying to beat each other up. They're trying to show their skill and proficiency, and you can evaluate that, right? You can watch people and say, you were a more effective mediator, you were a more effective negotiator. So that's what I mean by competitions. But our students are very deeply engaged in this. In our clinics, one of them is taught by our dear Professor Wright, where she works with my students to negotiate business deals, but a more classic mediation clinic. So we do family mediation, and we offer free mediation services with my law students and the professors, free mediation to people in family law, people in housing, eviction, landlord, tenant, and that is a crisis in the US right now because of COVID. So people who lost their jobs, can't pay their rent. We put a stay. We stopped evictions for a while. That stay is soon going to be lifted. So we are trying to help tenants and landlords work out how tenants can stay in their house if they are renting. So that's a big piece of my clinic. And then employment discrimination, claims of race or gender discrimination that goes to a state agency, and we help mediate those. So that's what we are helping our law students do. And that is happening across the country, small claims everywhere, that law schools are doing it. So where is mediation happening in the US? Again, my law school also studies mediation and brings in scholars and researchers. So that's why I can say that I'm up on what is happening, because I belong to national groups, and we bring those people to speak at our law school and law review articles and things like that. So I would say, and I'll be very interested to hear if it's the same where you are, but we do have court-based mediation programs. That is in just about every state. So our states, you know, our 50 states often do it differently. And I would say my state is not the lead, but we're somewhere in the middle. But our courts are very good. So there are mediators, some of whom are judges who do the mediation, but some are not. Some are lawyers, some are mental health professionals who are employees of the state and offer mediation. And we tend to do that in family, again, eviction of tenants, foreclosure, but also civil litigation. The one area where we used to have it, and sadly, it's not as robust as it used to be, is criminal law, which is too bad, because a lot of criminal matters, again, are fights between people who have a relationship. I'm not talking about domestic violence. I'm talking more about neighborhood disputes that get out of control and someone gets arrested by the police. We are trying to get that back into our criminal courts, but civil litigation, again, lawsuits about contracts and torts and other matters, business deals gone bad, very big mediation. But there's also private mediators. So what's been happening as it's grown is that both lawyers and non-lawyers have gotten trained to be effective mediators. And by training, I mean usually 30 to 40 hours of training. It could be in your law school class, but it could be just a 40-hour training, which, by the way, my law school offers too. And we train you to be that kind of effective mediator where you're not trying to tell people what to do. You are facilitating them to explore their interests, their needs, their motivating factors, as well as what they want. And by both together, we are a very strong proponent of what we call facilitative mediation, where people, and maybe they're lawyers too, but the people with the dispute are in the room and engaged. That's called self-determination. It is not that you send your lawyer off to settle your case. It is really that you are there talking with the person with whom you have a dispute. Sometimes you're upset, sometimes you're not. The mediator is there to keep the calm and to help the parties brainstorm solutions, be creative. And again, this may be that they're in litigation in court and they've come They've moved from court to this safe mediation room, and then they'll go back to court and say they're settled. It could be that they're never going to go to court. It could be that if they don't settle, they will go to court. They cannot resolve their dispute. But the idea is some people can use what we call private mediators, and some people set up their own business to do that. Family law is very much a leader in this area, but it is true that business, construction, it's funny, there's a lot of fights over construction. Any kind of dispute that parties have, there's a mediator available, either in the court or, again, saving the costs of going to court, hiring a private mediator. The big debate, and I'm going to wrap up soon, but the big debate where we are in the United States is, are we going to define that there's only one kind of mediation? As I told you, my school has a preference for this facilitative, work with the parties, have them in the room together. You know, sometimes they meet alone with their lawyers and the mediator, but normally willing to work face to face and come up together with the support of the professionals to come up with a plan and a solution that meets all their needs. So that is our preference, but that is not the only manner of mediation. So the issues in the US right now, and then I will stop and I'm happy to answer questions later, is there only one way to mediate? And right now in the US, it is no, there's more than one way. And it's really just a matter of telling the parties what you're going to do before you do it, number one. And number two, do we need to certify mediators, or can anyone just hang up a shingle, we call it, a little sign that says, I am a mediator? We have a strong preference for consumer protection and having some sort of training and background, but there is not a full agreement on this. So that is where we are in the development of mediation, debating those kinds of things, but it is getting more and more prevalent all around. So I'd love to hear from my colleagues, so I'm going to stop talking now. Nice to see my colleagues back on the screen. Thank you.
Thank you so much, ma'am, for giving your views on mediation and your experiences. It was a pleasure listening to you. Now we would like to start off with Meena ma'am's presentation.
Thank you, Farhan. And yeah, Carrie, that was really very interesting, and so many questions I have. Yeah, it's amazing how I like that in US the mediators started and then the lawyers took over. In India, it's lawyers started and others are taking over. Okay, so where do I begin? So Okay, so I have been working as a lawyer for like about a couple of decades now, and I chanced upon mediation. And I think even while I was practicing, I used to look for all those cases where people don't have to come to court, and why are they here? That used to be topmost in my mind. And somewhere I chanced upon mediation, and I said, this is so sensible. Eventually, I did the mediation training, and it was very difficult to be in the law courts after that, really. So today I'd like to focus my talk around courtroom versus the mediation room. Okay, so that was like my transformation in my mind happened at that time as well. So here I was in the courtrooms. My office is like, already when I joined it, it was 45 years old. And so we had cases like oldest cases on the planet in my office. We had archives were bigger, rooms were bigger. So, that means the cases were so old already when I joined in. It was not like fresh cases. We couldn't even read the documents properly, they were so old. So we had this one particular case, one particular family which had their multiple cases. It's like a starfish, you start one case and another starts off like that, like a starfish thing. So we had one particular cupboard dedicated to this particular family's cases. That family had that many cases. Imagine. So those who are in Bangalore, you would know all that Pottery Town in Nandidurg Road and those the places in Bangalore. So that was the case, and 40. It was already for 40 years, and that particular client's two daughters also became lawyers. You know why? Not because they liked being lawyers, but because they felt they can take care of their family cases. I mean, how sad is that? So, and then that's the second generation, and their children were also like talking, coming along to the office and the courts. This is what I would see, and I would be like, this is really sad. And I was doing my further studies in National Law School, and my dissertation was Bangalore Mediation Center. And here, call it serendipity or what, in the same month, I'm part of shadowing one mediation where there was this family, the mediation room. Courtroom is where nothing is moving. Nothing is moving. Everything appears to be moving, but basically nothing moves. And here in the mediation room, I'm not yet a mediator, okay? I'm just observing, shadowing this. There is this 30, 35 people attending the opening statement. The mediator is delivering the opening statement. And why 35 people? Because this is also a huge joint family property. Like Carolyn, we had this case sent over from the court to the mediation room. So, and the people involved were about 9 siblings, all above 70, 75, in various stages of illnesses. They were all sitting in the room around the mediation table, and nobody is looking at each other in the eye because it has been almost 30 to 35 years of litigation. They have not talked to each other. And because of the case and the friction in the family, and their children were also there. I think in India we have that. I think it's everywhere. When the opening statement is delivered, we have everybody, all stakeholders come for the opening statement. That's why the room was packed with so many younger generation people and all. And slowly I see the transformation from not looking at each other to another hour, 1 hour, 2 hours. By lunchtime, there were tears in the eyes of the siblings, telling them, please take what property you want. In Kannada, like, take it. All right, let's settle this, let's close this. And the mood of the entire room was changing from gloom to happiness and tears and emotions, high level emotion, like filmy drama unfolding. And I was shocked. I was so shocked to see here. And never have I seen in my court life this scene. I've seen many cases ending, but I've never seen this. And here, a couple of weeks back, this particular case I talked about, their case had gone to Supreme Court, and it was like over. The case ended in Supreme Court, and the family was weeping. In my office, the litigating family was weeping, and here in the court, this family was weeping with joy. And the matter settled. It closed. 9 siblings after 35 years or something, matter closed. So, I mean, really, think about it, Caroline. I was like that day, I think it was, I'm going to do this. This is what I'm going to do. I was so sure. And after that, I kept working at it. Mediations are very slow to combine in India, very, very slow. And I got into training. I created my training, which is more relevant to the Indian audience. Caroline, we are very filmy people, very, very influenced by Bollywood. We resolve easily. Yes, Farhan, we are not like, we don't. Families are very important to us. We all live in big families. It's very natural. Even I'm from a family. When I grew up, I was already an aunt. 14 people in my family. So living together, patching up, settling comes very easy to us. So I created my training in that tone. And it's a very fun, nice, it's not a 40-hour, it's shorter, but lots of learning, a lot of mocks. I have a cute presentation to share. Farhan, please check the time. See, I'm a lawyer, right? So I can go on. So you can Our time is up. Okay.
Actually,
Yeah, so please tell me. I'll do a quick share. So can you, the screen is seen,
yes.
Nitya? Yeah, okay, thanks. So this is something, I use for my presentation for everyone. So basically, this is what I feel mediation is for everyone, not for lawyers alone. Because in India, the more thing is like you have to be a lawyer for 15 years, then you can become a mediator. Now, of course, it is changing. So yeah, that's my so proud of having started that. So mediation, I think we all know, I don't have to repeat it. It's about a neutral person settling matters in a peaceful and amicable manner. What happens in a mediation room is something which is so fascinating, especially when we see the courts. It is so fascinating because parties speak in a court. Unlike parties speak in a mediation, unlike in a court, the lawyers speak a lot. And it's a very pleasant and a peaceful process, calm process. And how do people feel after a mediation? People feel very light and actually happy. They get to speak. They get to speak about things they have never even thought about, because a mediator makes them feel so comfortable to be able to open up. And when is it triggered? It is like when people disagree, when conflicts escalates and cause stress, or when relationships are at stake. Like even Caroline was talking about relationships, very important. And even when matters are pending in court, they can get into a mediation room. And who can seek mediation? Everyone and anyone can seek mediation. What happens when a conflict is not resolved? There are so many things that happen. We all know: shouting, screaming, stomping out, complain. People stop communicating, relationships just break, families break, businesses suffer, and we all see teams underperform with all the fights and all that happen, and negativity spills over everywhere. And what happens often when people go, someone tries to help others, what do people do? They immediately advise, or they say, come on, settle, be compromise, or they counsel, they volunteer to counsel the people, or guilt trip them, antagonize them, or sometimes people are very eager to resolve. Hey, come, I'll solve your problem, come. But you know what? Nothing works. None of this works. And who can mediate? That's why we have mediation, right? Because nothing works. That's why mediation. I'll tell you why mediation. A little deeper, I'll dwell into it. I'll be quick though. Who can mediate? Anyone can mediate. I have trained 9 standard students in English, and they have done a mediation in Kannada. I have taught mediation to 70-year-old aunts near my house, and they were able to, small matters. They don't have to physically, do a big thing. So why should we mediate? Because relationships come first. I can, I'm sure there's nobody disagreeing with me there. What are the steps? Mediation is a step by step process. I'll just quickly go into it. This is an international process which is taught all over. First, I use my favorite characters, Calvin and Hobbes, to go into that. Uh, First bringing people to mediate. That's the toughest part. It's the challenge all over the world. Getting people to the mediation room, and once they come, you make them feel comfortable, give them a space where they feel they can share, they can feel secure. So this is the first stage that is taught in the trainings also, how to get people to open up. And then we listen to people, we encourage people to tell their story, and then we gather information, just let them speak. And then what do? We focus. What does a mediator do? See, a lawyer looks at which case, what case, more facts. But then what does a mediator look at? A mediator is looking at the interest and needs of the people. Their interests could be as bizarre as, this guy Calvin trying to duplicate himself. But the mediator focuses on that. And that's the beauty of mediation. And what we do is we allow a win-win situation to happen between people. And then we evaluate options that come up, what to do this way, that way, several options in settling, and we enter into an agreement. An agreement here is not a legal agreement always. Several times it's a nice hug. Several times it's an apology. Several times it's tears of joy, promises. Yeah. So most of this is the part I feel every time I want to go into another mediation, this motivates me. It's always very nice. Some may not end into an agreement, but nobody goes back disheartened. A quick look at the skills a mediator needs. Listening well, not judging. Don't judge people, accept them when they're in front of you. And for me, the most important thing a mediator needs to have is willingness to help people. I want to help people. That's the base. All the other things will come very naturally. What's better? Everyone can learn to be a mediator. Anybody. I won't get into this activity I do. I will not get into it now. So see, this is something I believe that everyone has conflicts. There's nobody who doesn't have conflicts. It is what we do with those conflicts is what sets us apart. And a dynamic setup is there are many conflicts. बहुत झगड़ा, a lot of people, they're not agreeing with each other. How we handle those conflicts, how beautifully we handle is what a dynamic setup is. So here, this is something I've come up with one day. More conflicts means more growth, provided the conflicts are steered towards results. Okay. So this is my, I founded this, and I'm so happy to share this part. With me, there are a lot of people who believe in the philosophy of mediation. They believe that conflicts can be resolved. They don't have to go to court. So there are a lot of interns with me, lawyers with me, HR professionals, psychologists, research scholars. Basically, whoever interns, interacts, they become part of my team. And it's a huge team. Right now, I would like to end by saying that we need an army to work at peace in the society. Yeah, and we believe that we need to mediate and not litigate. Yeah, that's the end of my slides. Okay. Thank you. Hope that was useful. Also, thanks.
That was really great, ma'am. Thank you so much. Now we move on to the next course of the session. I would like to ask Nitya Bansal ma'am to start off.
Thank you, Farhan. Thank you, Meena, and thank you, Carrie. You both a lot of rich experience with you, which I don't think I have that much experience. So I'm really enlightened to have heard from both of you as well. And I totally agree with all the questions that Carrie raised. Some of them I might be touching upon as well. Some of the topics that both of you spoke will be touched upon in I've also prepared a presentation. So I will be speaking about similar topics, but I think it's more from a career perspective for the students. So it may be a little bit different perspective. But yes, I'll welcome any inputs or any. But yeah, one point I wanted to make on Meena's last line where she said that we need an army of mediators and for making peace. And, it's like just the same that for peace also we need warriors and we need an army, like a literal military or a warriors who will fight for peace. So that's nice. So thank you. Can I share my screen, Farhan?
Surely.
Okay. All right. So here I am focusing basically, I prepared a presentation to address, basically cover different career avenues. Am I audible? Yes. Okay.
Yeah, perfectly.
Okay. So yeah. to cover the different career avenues within mediation in both dispute resolution and conflict management. Now, generally, I think most of us, we use the terms dispute and conflict very interchangeably, and most of us, we understand that two to mean the same. So I will be touching upon a little bit of the difference between dispute and conflict. So basically, I think there's two schools. Some people totally agree that dispute and conflict are the same things. And there's other scholars who say and who agree that dispute and conflict are different. And I think I personally adhere to the latter school. And that's why, and I think it really makes a difference to understand the difference between, these two, because that helps us broadly understand what kind of avenues we have as a mediator when we think of a future or a career in mediation. So yeah, so dispute and conflict are basically, two different, not very different, but slightly different topics, different words. So dispute is definitely like a narrower term, and every dispute is a conflict, whereas all conflicts are not disputes. So some of the conflicts will not qualify to be a dispute, because disputes are mostly based in legalities. It's a matter of legal rights. And conflicts can also be based in your values and perceptions. I do not believe in abortion, or I believe in abortion. So, you basically, it's broader than just a matter of legal rights. A dispute is generally about consensual conflicts where, parties are fighting for the same thing. They want the same thing. They have common interests. And conflict may have basically dissensual conflicts where parties do not want the same things because they have different sets of values or they perceive things differently, and that's why the conflict happens. So because of this difference, generally disputes are easier to be resolved, and even if they don't get resolved, generally by judicial means or by adjudication means, you can always get a resolution or a decision by the court. But conflicts are a lot of the times very difficult. Like the broader conflicts are difficult to be resolved, and generally they can only be managed. And I think an example of a dispute would be where maybe a property dispute between two brothers or two family members, where basically both the brothers, they want the same thing. They have an interest in getting the greatest share in the property. So that's a dispute, but a conflict would be something more to do with your values and perceptions. So for example, a pro-abortionist versus an anti-abortionist, conflict. Okay, I'm gonna give, I don't know, do we have time, Farhan? How much time do we have? Can you prompt?
We have about 10 minutes.
10 minutes, okay.
Yeah.
All right. So I'm gonna give a very simple example to understand this difference between disputes and conflicts. So basically, like suppose imagine all of you, or basically you have two children, or you're a parent of two children aged 6 and 4 years, and you just celebrated the birthday of the elder child. And you receive some presents, and there's a chocolate which the younger one really, really likes. And as a parent, you allow the younger one to eat half or maybe the full of the chocolate. This really, really hurts the 6-year-old, and he fights and throws tantrums. He fights with the sibling and throws tantrums to the parents. So I would give all of you, like, maybe we don't have a lot of time, so maybe 20 seconds time to just think whether this will be a dispute or a conflict. And I think you're free to comment if that's an option.
I think Alina and Rafat can take it up.
Come again? They mentioned something? They commented?
I think Alina and Rafat, who are on screen, can take it up and give their opinions on it.
Yes. What do you think? Rafi and Alina, what do you think? Is this a conflict or a dispute?
I think that this is a conflict.
Okay.
Yeah.
Do you want to elaborate why you think so?
Just a minute.
Okay.
Okay, so I think the 4-year-old and the 6-year-old, they both have a fight, and there is a conflict of interest here, where the older one the parents think the older one, should not eat the chocolate, and the younger one should eat, because the older one, generally fights. Uh, so this is what I think.
Okay, okay, great. So, okay, I'll actually just move on to why so according to me, it has both components of a dispute, and it's definitely, I agree with what Farad said, that it's a conflict, but it also has an element of dispute. So if you look at it technically, like from a legal perspective, if a gift is received for the 6-year-old's birthday, then technically the gift belongs to the 6-year-old child, right? So if you look at it just from that perspective, then there's a dispute aspect as to who the present belongs to. But then there's probably the bigger conflict, which makes the 6-year-old child more hurt, because he may feel that, my parents always give the chocolates or always give my presents to the 4-year-old, or he gets a share, like he may have all those, which I think a lot of elder siblings end up having when they, then as youngsters, they have their younger siblings born, that, they feel the little bit of rivalry. So, there's broader emotional component which cannot be really resolved using legalities or a right based attitude. So I think that is what a conflict is. So so I'm going to move now. So based on this difference between a dispute and a conflict, I'm going to basically be talking about broadly as a mediator. This term mediation is used for different types of mediations. And I think we did mention, even Carrie and Meena, they both addressed the different types, some of the different types of mediations in their presentations. But I'm going to broadly cover like majority of the types of mediations. So you can basically, somebody can be a mediator in a dispute resolution. Like it's the regular mediation as part of the alternate dispute resolution. And okay, I have basically divided my this screen on three parts. One is dispute resolution. Second is dispute resolution, which does involve some aspects of conflict management. And the third is purely conflict management. Now, from my perspective, and I don't say that this is the only perspective or this is the only correct perspective, but basically dispute resolution from my perspective relates mostly and only with legal rights, whereas whenever relationships and emotions come in, it involves a lot of conflict management as well. So it's not to say that dispute resolution does not have conflict management. So a lot of the times dispute resolution involves conflict management, but there are some cases where there's not much emotion involved in disputes, such as, purely commercial disputes, contractual disputes, business to consumer disputes. So in those cases, their mediation still happens, but there may not be conflict management involved because you don't need to really address the parties' emotions and the relationship. Then there's the other dispute resolution, which involves aspects of conflict management, where basically, these are the disputes arising in family law matters, neighborhood disputes, even in criminal law to an extent, like Carrie also mentioned. There's a dispute component and there's the emotional component involved. And to address both those components, it basically a mediator should address like both dispute resolution part, which is like law based, as well as managing the relationship between the parties. The third is conflict management, which is like pure conflict management. And in this, there may be a dispute component, but generally, so it's a broader term, which is used also for conflicts like where there's there's inter-community conflict, there's an interfaith conflict, inter-ethnic conflict, so even international armed conflicts. So a lot of the time, the armed conflicts, they're not based in, legally a dispute. It's just there's been growing antagonism over ages between two tribes or between the people of different countries, and that grows into an armed conflict. Such disputes cannot really be settled through courts. So these are called conflicts and they may not always be settled, and that's why you need to basically manage them, and that's why they come under the head of conflict management. So these are the three types of mediators. You can be a mediator, and basically in international conflicts and wars, As a mediator, what you'll be mostly doing is diplomacy. Most of the diplomats and foreign relations people, that's what they're engaged in, which is managing the international relations. Okay, so these are the three types of broad types of mediation career avenues. Among the very three types, okay, I'm going to just touch upon the dispute resolution, which is the purely commercial disputes, mediation in purely commercial disputes. I think mostly it's the lawyer mediators, the mediators who have a law degree and who have knowledge in law, that those are the ones who address that. The second component, a lot of the times lawyer mediators, as well as there are, community elders, respected citizens, common friends, elders of the family, relatives, they also do this kind of mediation. And the third kind of mediation, which is the international or inter-ethnic or interfaith mediations, that is mostly done by respected public figures, diplomats, representatives of friendly states, international organizations, and INGOs. Okay, so having covered that, I'll definitely take questions if there's more questions about this during the Q&A session. But moving on, so here I have basically broadly mentioned, what are the different types of mediations or the terms that we hear, mediation terminology that we hear. So there's, based on the stage of conflict, there's and the stage in which the mediation is conducted, there's pre-litigation mediation, as well as there is post-filing litigation mediations. So pre-litigation mediation is where a case goes to mediation before it has been filed to the court, filed in the court. And I think that the main reason for this is to save the relationship from being spoiled before it goes to the court, as well as to save the burden from the courts. Then there is post-filing litigation, where once the parties have already gone to the courts, then either because the court refers them or because the parties realize or the lawyers advise. So while the matter is already pending in the court, parties simultaneously approach mediation. So that is the second pending or post-filing litigation mediations. Then we go on voluntary mediation. So based on how a party or the manner in which or why a party chooses mediation, we can say there is voluntary mediations and there's mandatory mediations. Voluntary mediations is where parties themselves choose, but there's also mandatory mediations, like especially I think now in India also, I mean, family matters, and I think all over the world for family matters, mediation is, divorce matters, mediation is almost mandatory in almost all countries probably. Or then there's a lot of commercial cases where there's mandatory mediation before the parties approach the court as well. So it depends. So where the mediation is mandated by law, there it's mandatory mediation. Where parties choose to go irrespective of whether it's mandated or not, there it's voluntary mediation. Then there's based on the affiliation. So there's private mediations, which basically lawyers, law firms, or mediators, they do it themselves. They can do it ad hoc, or they can be associated with private mediation bodies or organizations. And then there's also court annexed or court mandated mediations. Court annexed mediations is where you're impaneled on some of the court panels, and the courts, once the matter is being heard by the court, they may appoint or they may just assign a matter to go to the court annexed mediation center, where the mediators may be impaneled, and the mediators basically mediate those matters. And once there's a settlement, they will send the matter back to the court with the settlement. So these two. Then of course, these days, there's a lot of online mediation, e-mediation. So based on the mode of mediation, generally, traditionally, and there's these two groups, one that say that, in-person mediation is the best, but then there's also the online mediation one. So and then based on the nature of conflicts, there's community justice mediation, there's restorative justice, which is also a form of mediation in criminal matters, and family matters, commercial matters, etc. And this is again based on the mediator type. I think this is a whole separate topic, so I will not go into the details. But yeah, there's these three types of mediation as well: evaluative mediation, facilitative, and transformative mediation. I think, yeah, that's all from my side. And I don't know, I hope we are left with some time to take question and answers. So on over to you, Farhan.
Thank you so much, Nitya, for that excellent presentation. I think all of us can be back on screen now. We'll take up questions. I think first I'll ask of Alina to start off with the question. Alina, you'll have to unmute yourself.
Yeah. I wanted to ask a question with Caroline, ma'am. How can we increase the role of mediation in the criminal field?
Was that for me?
Yes, ma'am.
Well, in my little state, it really was just a funding problem. As I said, it was flourishing, and then some state government funds got caught. They would take volunteers, but they're not at the moment having funds to pay. So I think it's going to be different in different places. But here's what I really think. If you take the money part away, which, you know, that's hard, but it's getting to the what we call prosecutors or state's attorney or district attorneys to help them understand that they need to identify some cases. Well, it could be earlier, you know, training police to refer cases instead of arresting. So it's really going to law enforcement and prosecution, helping them understand what mediation is and what kinds of cases could be referred to mediation. So in police, when they go to a neighborhood dispute, instead of arresting, referring them to a community mediator or something. But once the case is in court, then it means both mainly prosecutors understanding the value of, again, making a referral to mediation and then seeing what happens. Obviously, defense counsel and the parties themselves, the arrested people, could say, can we try mediation? Sometimes in criminal, both parties are arrested. Sometimes they're considered a defendant and a victim. But what's interesting in when it's working well is that it's almost like a you interrupt the criminal prosecution, send them to the mediator to see if they could work it out. And then when it comes back, if it also wasn't very serious with injuries, the state, in our case, or the government or the prosecutor would decide, okay, you have an agreement. I'm going to dismiss this case. Or maybe it's a little more serious or these people have been fighting for a while, they might say, we're going to hold your case, see if you can reach your agreement. If you start fighting again, we bring the case back. So there's a little bit of power behind the agreement. But in a perfect world, it would be one of those situations like Nina suggested, where there's this breakthrough and crying and apology and a real change in behavior that the prosecutor would have to say, I believe you, that you finally have this agreement, and then the criminal charges go away. So I really think it's about getting to and educating both police and prosecutors about how powerful mediation is.
I think that was quite an interesting question, and I would like to know Meena ma'am's opinion on the same question. I would like to ask her if there are criminal matters in which mediation can be done, and how can this be done effectively?
Yeah, this is something, honestly, instead of giving answers, I would like to tell you what I am exploring right now. In India, we have criminal matters in Negotiable Instruments Act, compoundable kind of offenses, you know. Of course, Negotiable Instrument Act, we have mediation. We are exploring in India, but recently I came to know about restorative justice kind of thing being introduced by one of the police officers. It's interesting that I'm going to meet him next week about this particular thing, where we bring little compassion into the police station itself when the victim is brought at that stage itself, you know. So in criminal matters, I think what Caroline was saying is true. We can explore it and hold the case if most important is the prosecutor feels. That is such a big thing. It's almost like, a divine thing to happen. But if that happens, I think it should be explored. Uh, and I think we will have more, the people who will benefit most will be the ones who are wrongly convicted, wrongly accused, and they are lounging in jails. That kind of scenarios it will help. But it is very, very nascent. It's just an idea, very nice idea, but I don't think it's so thing in India yet. We are still figuring out in the civil area itself. So it's not going to be easy. I don't know if I answered the
I
matter,
can
but
say
that's my space about criminal lawyer.
when you say you have to get to the prosecutor, it's true. I happen to be married to a prosecutor who is now retired, but maybe about 20 years ago, he was skeptical. But there was a mediation program in his criminal court. He started making the referrals, became a true believer, and spoke with other prosecutors. So I think you get one. I just happen to be married.
How nice!
But
That's very encouraging.
yeah, I think I might have had something to do with his willing to take the chance. But it's personal relationships and talking to people, and then other people adopted it. But yes, it is. I agree. It's all about getting to the power brokers in the criminal justice system and helping them see, telling stories about successful mediations.
Yes.
It's possible, but it's hard work to change. In the US, it's a very strong culture against this kind of work. So we're going upstream, we call it, like fighting against the current.
Same here. It will be.
Good evening, everybody. I have a questions to ask. It is for Nitya ma'am. Ma'am, it is often seen when there is mandatory mediation given by court in India, the lawyer tend to have this mentality of neglecting the process of mediation. So what can be done in order to keep the spirit of mediation alive in India?
That's a brilliant question, Rafid, right? Rafid. Okay, so Rafid, there's this, in fact, I don't know if Kim has already organized something on this, but there's this movement called collaborative law movement, which basically focuses on mediators to not, basically lawyers and mediators to be a totally separate and exclusive profession. So anybody who's actually a mediator or even representing a party in a mediation should not be their lawyer, because that's what happens. If a lawyer is going to represent the same party in mediation, then there's going to be conflict of interest. For India, I think that's a little difficult right now because parties mediations, success rate is still not very high because mediation works on healing the parties. It gives them a venue to share and to get some closures, but to actually reach a settlement and to get that legal closure, I think that the success rate is very low, and that's why people don't want to pay. And I think even funding for generally for mediations is very little, and that's why that it's very difficult for people to have full-time career as a mediator. So I think, but yeah, in a perfect world, that will be the solution: collaborative law.
Okay, ma'am.
Yeah. Do we have any comments? Is Panna there?
I see a question. I can't answer it for India. What I can say is in the US, it is more like 90% success in family law. But what is the experience in Indian courts?
Coming to the Indian courts, what I have seen is, Hitesh, regarding the husband-wife cases, the success rate has been very high. I've not seen all the states, but in Bangalore, success rate is high. And I was very amazed myself because when I was talking to one of the directors and we had a long chat about it, when the matters are new, new matters, people have been married very newly, first few years, first 2 3 years, the philosophy is that there will be a lot of friction, but now people are resorting to a divorce very quickly, unlike before. So they have been success rate to these kind of marriages has been more. And I'm not simply saying it. This director has even catalogued about, in his tenure of 8 months, he was in the mediation center. He catalogued all the people who have, changed their mind and they started living together after the mediation session. He had about 75 cases catalogued that people have gone back to living together. So in family matters cases, yes, some of them are wasting time. One of few are there, but the success rate in family matters in the mediation rooms in annexed with court are very high, where they're settled easily, more properly than before.
I have to say, I think in family matters, it takes a special kind of training and a special kind of skill because of the friction that you talked about, Mina.
Yes.
So if anyone is seeing a lot of failure rate in family law, they need to go back and get more training.
But also,
Put aside the domestic violence cases, that's a different
Domestic
set.
violence, no. Yeah.
But well, we are developing methods for mediating domestic violence, but it's a different kind of mediation. And but for basic family law, where there's hurt and grief and a suspicion, but no violence or serious mental health problems, so their safety is okay, then maybe we're looking at mediators who need more training there, because normally the rate is higher, as Mina said.
Yes.
if I can add to that, for India particularly, I think one of the one in my experience, one of the main concerns or is the fact that many of the women are economically dependent on the men. So I think a lot of the times they don't really have that much of a say in the mediation. Is something I experienced, but also I think I wouldn't entirely say that there's 95% mediation, because it depends on what you mean by the failing of mediation.
Very
Mediation,
true.
yeah, mediation can allow a party to even vent. And I think if that venting has helped the party to heal, then also, even if it didn't really lead to a resolution or a settlement, so long as it caused some, emotional healing, I think it's still been a success. So,
Yes, yes.
Agreed. Yeah, we always have to be careful in mediation not to define success as settlement.
Settlement, yeah.
That's way too narrow a definition. And I think then there's danger in having that be the only way to measure success, that the mediators get invested in the settlement and start pushing. And family law, to use that example again, is one where the more the parties participate and the less sort of coercive, evaluative, directive the mediator is, the higher the satisfaction, the more likely the agreement will hold. Because it has to be a durable agreement, one that's going to survive when there's an ongoing relationship, like parents. If a husband and wife had no children and they're going to go their separate ways, perhaps that's okay. But when there are children, it's not about getting settled. It's how they're going to live their life as separated parents to those children. It's being divorced or separated, not just getting them divorced. So if you get too directive and coercive and pushy, it's not their agreement, and they're the ones who have to live with it. When 5 years from now they have a disagreement on something from their child. So I completely agree that the danger in mediation is defining success equals settlement rather than just and one step closer to resolving the conflict, maybe someday in the future.
I think Farhan is facing technical glitches, so I'll ask a question for all the speakers on board. So the question is, can there be mediation done in course of providing criminal justice? is this process feasible in case of criminal matters?
We just covered that, right?
Yeah, I think we covered that one.
Okay.
I think Alina just asked. We just covered that.
Yeah, he asked it.
Yeah, I don't have anything more to say about criminal. I think, well, I would say one other thing. It's important not to, if there's a victim, it's important not to force the victim. The victim gets to say yes or no, going back to that concept of voluntary or mandatory. You can make it mandatory that the people have to get asked about mediation and whether they want to do it, but in fact, they really need to, it's not going to work unless they're staying in the process voluntarily. You can set up a mandatory process that you have to go and talk to the mediator, but once you're there, if you're not voluntarily going forward, nothing's going to prevail. So in that case, the victim needs to feel safe. That's the only thing I would say more about feasibility, and I think we touched on it. But I do have a question for Mina. I mean, there's a situation, Kim Wright has asked us, do we have questions? So when you were talking about families and sort of the peaceful nature and big families, et cetera, I was struck that I do believe, apart from just criminal, that I think the cultural differences in our countries have accounted for some of the different ways. I was fascinated to hear you, lawyers started it, and I'm thinking, and it's still going 30, years ago, the lawyers didn't mess it up already, because it's certainly mediation. I'm not going to say there weren't lawyers at the beginning who helped, but as I said, it was the US culture of individual rights, not relations, which is a sort of the undercurrent. And therefore, the lawyers pick up on the adversarial. There are still lawyers in the US who are very resistant and frankly ignorant of what mediation really is. Even now, I have a hard time believing that's true after decades of this. And I do think that's part of the cultural difference. So do you have some thoughts on why and how the cultural difference? I mean, you gave some great examples, but I wanted to ask you a little more on that.
Yeah, it's like, I think we can dwell on every statement and, it just goes, you got to look at it in a larger perspective. When I said lawyers started, it's like, it started with Supreme Court of India, the judges wanting it. Of course, we had a few people writing in about it, but it started because Supreme Court made it mandatory that mediation, we should resort to mediation. And then the judges started it. Then a few lawyers got into it. So many people got trained. And then it was so much that to become a mediator, you had to be a lawyer for 15 years. That was the mandate.
Wow.
It has changed now. So a lot of lawyers got into this, and a lot of lawyers were already doing it. I will not say all, small percentage, but they were already doing it. And then they got trained, they trained the other lawyers, and it trickled down. We don't have a lot of private mediation in India yet, but it started out in the legal space. It didn't start with individuals. Like you said, America, it's US and all, it's more about individual rights. Here, it's not so much. We are, we're so many diverse, we're so diverse. It's like diverse is the word. There's no coming together for a lot of things.
Okay. Thank you.
I think we have a follow-up question from Hitesh. And although I'm not very sure what this question means, but I think I can try to answer. So I think what Hitesh, it depends when you say mediation failed, even courts. Sometimes what it means is basically, especially in matrimonial matters, we assume that a successful mediation is where the parties and the matrimonial parties, they will go back in matrimony and they will, so we, if parties even mutually agree to divorce, that may be seen as a failure of the mediation because the parties didn't go back to into the matrimony successful. So I think that is one point to be considered. But yeah, also I don't know exactly the basis of this statistics. So yeah, but so I hope that clarifies.
I think with this, we'll come to the end of the session. I would like to ask Kim ma'am to give a few concluding remarks.
So I've really enjoyed this. Everybody had such great perspectives, and added a different element to the conversation. And I thank you so much for coming and sharing your time and your expertise. And I just want to also, I put this in the comments here for the presenters, but one of the big differences culturally is that in the United States, about 50% of marriages end in divorce, and in India, it's 1%. And most of those are domestic violence from the research that I did a few years ago. And so, the cultural differences are huge, and in the United States, we're not so focused on it's a failure as it is in India, and so I think that I want to add that to the conversation.
That explains a lot to me. Thank you so much for that. I should have asked that question earlier.
But thank you all so much. Thank you, Farhan, for hosting us again, and Alina and all of the rest of your team for all the hard work you do to put this together.
Thank you so much, ma'am. On behalf of the entire team of Law Essentials, I would like to express my heartfelt gratitude to all the speakers who have been on board with us today. I would also like to thank Kim ma'am for always being supportive for the Center on Integrative Law. Thank you so much for attending the session and also for speaking.
Thank you. Thank you, everyone. Thank you.
My pleasure.